On October 15th of last year, the Senate President, Martin Looney, sent a letter to the Sentencing Commission asking it to submit a proposal by the end of this summer that would reduce the pretrial detention population, eliminate money bail so that release would not be dependent on wealth, and to assure that public safety was not jeopardized. A working group within the Sentencing Commission had been working on this issue for quite some time, and late last fall, the Commission asked me to try to help resolve the differing concerns that different representatives of the criminal justice system had in approaching this issue and to enable us to put together such a proposal. I wasn't asked to do this because I once prosecuted cases, although I did have my first jury trial as a student prosecutor in Massachusetts, nor was I asked because I spent a lot of years as a criminal defense attorney with a much lower batting average in jury trials than I had as a prosecutor, or that I had spent many years as a criminal justice consultant, including being the evaluator for the Clark Foundation, the funding organization that began the sentencing project that Mark Maurer is here to represent today, nor that I spent 21 years as a judge. The real reason that I'm here today is because since leaving the bench 7 years ago, I now work as a mediator, which means that I've been spending the last several years working on ways to find consensus and compromise in matters where two or more sides have contrasting, opposing, but responsibly stated points of view. So this panel discussion is an early step in trying to identify the issues that might hinder us in trying to approach the issue of eliminating money bail and to move toward something that resembles consensus. In this process, although I have my own personal feelings, I am a neutral. And what we want to do is be able to produce a proposal that enjoys the complete support of the entire criminal justice community. We all know that wealth inequality is a fact of life. But my conversations with members of the panel, other members of the advisory group on pretrial detention and release, and others all lead me to believe that there's probably nobody in this room who disagrees with the notion that there is something fundamentally unseemly, unjust, and just plain wrong about a system in which financial status determines whether presumptively innocent individuals remain behind bars or not while their cases are pending. We all agree on that in principle. The devil will be in the details. We also understand that a severe negative impact of that disparity falls disproportionately upon people of color, which is really the overall overarching issue on our table today for our discussions. I think we also all understand, at least I certainly understood this as a defense attorney, and that's that one's status pending disposition, in or out, can play an enormously important role in determining the ultimate disposition of a case. A person who is free on bail or on a promise to appear is able to help participate not so much in his own defense necessarily, but in helping to use the period between arrest and ultimate disposition to enhance the prospects of a successful and productive outcome. And by the way, we frequently discuss this whole period as pretrial. I think we all understand we're not talking about that. Anybody know what a trial is? I mean, yeah, there are some trials, but we're really talking about status pre-disposition. Most cases will be resolved either by a plea of guilty or by a nollie. A teeny tiny percentage are the result of trials. Pretty clearly, if we could find a way to remove money bail as a condition of predispositional release, we could solve a lot of problems and pave the way toward more intelligent, more productive use of the criminal justice system. Before we get into that into some detail, I think it's important that we address two things. One is a principle and one is a law. The principle is a principle of chemistry. It's one that I didn't learn in my 1 year and 1 day of being a pre-med before I learned I couldn't do science. It's something I picked up a lot later, but I quickly realized how applicable it was to social systems, and in particular the criminal justice system. It's called Le Chatelier's principle. Anybody know it? Stump the experts. Le Chatelier's principle says that if a system in equilibrium is changed in any way, the system itself will shift so as to tend to minimize the effect of the change. If a system in equilibrium is changed in any way, the system itself shifts so as to minimize the effect of the change. A good example is one I think that Judge Devlin will remember from our respective youths, when his former boss, the Chief State's Attorney in New Haven, embarked upon a policy of no plea bargaining. When he instructed all of his state's attorneys, his assistant state's attorneys, not to plea bargain any longer. So what happened? Did every case go to trial? No. Did the system come to a grinding halt? No. The presiding criminal judge at that time, the late Frank Kinney, devised a system of what we now understand to be judicially supervised pretrials. He would call the prosecutor and defense attorney into chambers, ask them to describe the case to him. He would announce what his sentence was likely to be if there was going to be a plea of guilty, and life went on. The system itself shifted so as to minimize the effect of the change. And that's something we need to be on the lookout for here as we talk about how to go about the process of eliminating or reducing money bail in a way that doesn't allow the system to kind of double back on itself and leave us right where we left off. The law that I'm going to talk to is one actually that Mark alluded to in his comments. His was in the context of a dam in a national park, but it's the law of unintended consequences. There are lots of ideas, of policies, of laws that start out with good intentions, and they wind up producing unexpected and often disastrous consequences. For a really good example, think prohibition. Let's stamp out alcohol abuse. How did that work out? Not so well. Okay. So what could possibly go wrong with the idea of eliminating money bail, a concept with which all of us agree is fundamentally inconsistent with all that we stand for as a democracy? Well, it turns out there are some things that could go wrong. Something very similar was recently tried in New York, and already within 2.5 weeks of its implementation, serious efforts are being undertaken to try to either repeal it or undermine it. So I've already learned in speaking to the members of our group that from each of their various perspectives, there are things that they're worried about that could go wrong, even if they support the concept of elimination or reduction of money bail in principle, and that's what we're going to ask them to talk about. The goal of this panel is to try to identify the most important of the concerns that each of them have from various perspectives, and then to work toward crafting a proposal that eliminates or at least minimizes the worst of those concerns and the most serious of those concerns, and enables us to move forward with the proposal that I mentioned at the outset. Our panel represents a free market supporting nonprofit group, the State's Attorney's Office, the Public Defender's Office, and the Judiciary. And what I'd like to do for starters is to turn it over to them one at a time to kind of outline what they see as what might happen with this kind of proposal and what they're worried about. Then I and they, and I hope you, may have some questions that we want to ask to try to flesh these issues out. With that, I'll begin with Isabel Blank, who represents the Yankee Institute.
Hi, thank you for the introduction. So a lot of you, if you've heard of Yankee Institute in passing or in less than passing, I might seem like a weird addition to this panel, but I'm really excited to be here and explain to you why Yankee Institute is an important part of this discussion. We're excited to be here. So what you might hear about us working on is fighting against tolls or tax increases, and I want to clarify that we are much more than just an organization focused on tax reform. The first reason you might think we'd be interested in this issue is for taxpayer savings. That's kind of face value. An organization that wants to save taxpayers' money would, like the elimination of bail to a degree because it does save money. So on face value, it's about $120 per day per inmate as a cost to the state. And that's a waste of money in our eyes if those people don't belong in prison, just on a financial basis. If someone's on a flight risk or a threat, that's not a good thing to be paying for them to be imprisoned. But another reason is the opportunity costs that come along with putting people in prison. They're not being the productive members of society that they're meant to be and that they are. And then there's also unintended consequences once they're released from prison that would make them less productive in society. What people might not think about when you think of Yankee Institute and our involvement in this issue kind of goes back to our tagline, which is free to succeed. So we strive and support policies that make sure that everyone in Connecticut is free to succeed and eliminates barriers to people in the state. So that includes reforming policies that hinders freedom because of economic status. And that is an unintended consequence of the bail system that we have in place. So everything that we work for, we work on and support, and we do it because we believe it's the most effective way to raise people up in Connecticut, and pretrial reform is no different. In terms of our fears, I think everyone has a fear in policy changes that it's not going to work, right? So in this case, it could be that we end up putting more people in prison, and we don't want that. Or it could be that we release people pre-trial that are dangerous to society. So I think we all have a fear that, we need to make sure we're creating this system in a way that eliminates some of those issues. So I think that as a group, we come from all different sides and different areas and are different stakeholders in a way in this issue. So as long as that we're having these conversations, we're looking at case studies, and we're involving all the important parties, I think we'll be able to curate eligibility requirements that would make this reform successful.
Thank you. Kevin Lawlor is our Deputy Chief State's Attorney.
Thank you for having me, Your Honor. I think, from the Division of Criminal Justice standpoint, and that's, the 13 state's attorneys and the chief and the 2 deputy chiefs, we understand, the seriousness of this issue. This is not something that we are diametrically opposed to, I don't think, in any way, shape, or form. I think we're all interested in having a system that is fundamentally fair, that is a system where the public is protected, and also a system where we can assure people's appearance in court. I think that those are the 3 goals that whatever system we have should be of primary importance. So for us, we're not opposed to the idea of bail reform, but whatever system it is that we have should have those 3 criteria as the most important factors, I believe. I think that what we can do, or the concerns that we have that I've illustrated to members of this panel before, is really, the issues concerning more the nuts and bolts of how this would occur. And I know that other members share those concerns as well in that reflect their own particular interests. For us, the questions really are, more nuts and bolts of, just is it going to be an offender-based system or is it going to be an offense-based system? Because we've all seen that there are offenders who maybe commit lesser offenses, particularly in domestic violence issues, where the crime could be of a relatively less serious nature, and yet it's someone that all of the data is telling us is someone that we should be concerned about. So I think that that's one particular area where we have issues. We also just really want to know kind of the nuts and bolts of how any detention type hearings would proceed. What would be the level of proof that would be required? Would there have to be live testimony? Prosecutors in the field know how hard it is to get witnesses to come forward in the first place, particularly in areas like domestic violence. To tell them that they have to come into court and testify as to what just happened to them. It's hard enough to get them to complete a police statement as opposed to even getting them into court. So those are areas where practitioners on a daily basis see it as an issue. So we're not opposed conceptually to reform. There's always a better way of doing these things. And certainly with the system that we have now, everyone can point to a case where we can see that something's just not right, whether it be someone who's charged with an incredibly serious crime who happens to be out on bond, or someone who appears to be on a relatively minor bond and is being held. So those are the kind of things that we can all point to, and no matter what we do here, there's always room for improvement. So whether it's bail reform to the degree that maybe we're talking about, or whether it's lesser reforms that we can work within this system, I think that those are all goals that I think the people on this panel are committed to, and that certainly the state's attorneys would support as long as it promotes public safety, fairness, and assures that the defendants who are charged will appear in court.
Thank you, Kevin. Chris Rapillo is our Chief Public Defender.
Thank you, Your Honor. So, the Division of Public Defender Services, I mean, our agency is the one that's representing the folks that are being held. Our mission is to represent indigent people who are accused of crimes. So it might surprise you to know that our division has not jumped on board with both feet to this idea that cash bail would be eliminated, because the question is, what is it going to be replaced with? And our concern is that if cash bail is eliminated and it's replaced with a system of preventative detention, that it will result in more people being held, and that it will not have any significant impact on our poor clients, and will not assist in their ability to be able to be at liberty while their cases are being processed. So these eligibility requirements, so what we've talked about a lot is the devil's in the details. So if you eliminate money bail and you replace it with a system of preventively detaining people who are determined to be at risk, what charges are eligible for preventative detention? The parameters of the discussion so far have included things like dangerous misdemeanors, dangerous felonies, people who present a risk to themselves. So those are all of concern, because now you have a body of people who are at liberty either on unconditional release, conditional release, or by posting a money bond, who are out, who are not reoffending, who are able to be productive in their lives, who are able to try to support their families, who are able to keep their apartments, who are able to maintain whatever jobs they have. And in a system of preventative detention, they'd be unable to do that. We also share concerns about what would the process look like. To preventatively detain somebody implicates a much bigger liberty interest than the issue of, I mean, it's still the issue of somebody, whether they can get out of jail or not. But by setting a money bail, you still leave the possibility that somebody might be able to get out. And the determination that somebody presents a risk so that they need to be preventatively detained essentially takes that away. So there's a number of concerns about that. We already have a system where there's very few cases that go to trial, where clients, because they're concerned about the impact their case is having on their life, will choose not to contest a charge. Even when it's going to have negative collateral consequences for them, we may not have all of the evidence in front of us, but people want to get their cases over. And it's much easier for somebody who's out to be able to defend their case than it is for somebody who's in. Somebody preventatively detained who now knows there's really no possibility that their family would be able to get together money to get them out, or that their lawyer would be able to make an argument that would really significantly reduce their risk level. We're concerned that that would make the system more likely to induce pleas from folks, when maybe it would be better that at least a few more times people were testing the weight of their evidence with a trial. So we have concerns about that. There's also concern, I mean, preventative detention model uses some sort of an assessment. Is it a risk assessment? Is it a needs assessment? Is it a strength assessment? And there's lots of discussions about what are the implications of that for the disproportionality that we're here talking about today. And people will talk about assessments that have been screened for race and they're race neutral, but it is very difficult, if not impossible, to have any sort of an assessment tool that's truly race neutral. Because the criteria that people use to assess risk all come with race-laden factors. Things like poverty, things like people's zip codes, where they live, people's criminal records, as we've heard before. Different communities are policed differently. So you're not truly necessarily measuring somebody's level of criminality by looking at their criminal record. They just live someplace where they're going to get picked up for things that maybe somebody who lives someplace else isn't going to. So those are all concerns that we have. Now, we also, bail reform is an important thing, and there's definitely work that we could be doing to make the system more fair and to ensure that people who are safe to be out could be out, and that people are not being held just because they can't afford to be released. There's a lot of positive things that have gone on in Connecticut. The prison population in Connecticut has dropped dramatically over the last 10 years. What hadn't happened up until very recently is any movement in the pretrial population. So there's monthly indicators that get released by the Office of Policy and Management every month, And the newest ones are starting to show a drop in the pretrial population. There was a 14% drop in that population from 2018 to 2019. And it's dropped below 3,000 people for the first time in decades. So what I would encourage us to be able to do, and what we would like to see, is more investment in the services and the things that get people out of jail and that keep them out of jail. One really good example is this Treatment Pathways program. It's a substance abuse program, and it's not a perfect program, but it is a program that showed real promise in getting people with substance abuse issues, who would likely be people who would risk high and who may be committing crimes like burglary and perhaps domestic violence offenses that would lead to them being incarcerated, being in jail. Well, that's a program, it saved $85,000 in bed days, and it's a program where they're only able to take in about 2/3 of the people that apply and who might be eligible. So perhaps combining looking at what crimes do really need to be eligible for people to be locked up at all. Do we look at something like what New York did? Maybe not exactly what they did, but something like what New York did. Do we look at trying to support the services that keep people out of jail? And I think that could probably be done in a way that balances the cost. Programs cost money, jail costs money. But the idea that the system that we have would be eliminated and it would be replaced with a system of preventative detention, again, concerns me, because I think the folks that we're looking at, indigent folks who are accused of crimes, I don't know that this system, as we've sort of currently been discussing, without some details around it, would benefit our clients.
Thank you. Judge Devlin.
We went to Washington, D.C., which is seen generally as a gold standard of pretrial release. And, you know, the number of people that we release in Connecticut as a percentage of the arrests really compares quite favorably to the numbers in Washington, D.C. And we have a really robust pretrial services unit in Connecticut. I think it's one of the only ones in the country that's really certified. We visited New Jersey, and they had zero pretrial release resources when they implemented their no cash bail system. But it is true, and it's worth highlighting, that up until just like last month or so, our jail population has gone down by thousands and thousands of inmates, but the number of people held pretrial has remained steady at about 3,000 people. We went from almost 20,000 people in jail to 12,000 people in jail, but that 3,000 pretrial level has remained pretty much the same. And of those, today, we've got about 500 people locked up in Connecticut on misdemeanor charges. And yet we have people out on $1 million bonds who have allegedly committed murder. That's the problem. I mean, that's the problem. So if you had a transparent system where a judge makes a decision on the record, on evidence, look, this person should be detained, this person should not. And, you know, like Judge Silbert said, I think at the edges of our system there'd be changes, but the fundamental heartland of our system probably wouldn't look that much different. Most people are released in Connecticut on either promises to appear or some sort of a money bond. I suspect that would still remain the case. It would just be a system that was, you know, more honest. Someone would stand in front of a judge, a prosecutor, and I think it'd be by proffer. Almost every state that does this by proffer. We don't have witnesses, they don't have witnesses come in, but we could look at that. And there's important questions about eligibility. Where do you cut off people that are eligible for detention and not? And I'm not saying those questions are easy, but other states have worked through them and made different choices. But I think the system itself would be a more honest, more transparent, and overall, I just think a better system. Thanks.
Thanks. Let me ask a clarifying question, if I may. We often describe bail in terms of being something used to prevent flight to avoid prosecution. My sense is, and I hope people can correct me if I'm wrong, is that almost nobody flees to avoid prosecution. People miss court, maybe a couple times, they don't show up, but very few people actually flee the jurisdiction. Does anybody know anything about that? Do we have any answers on how many of the people who are either released on promise to appear or on bail actually take off?
We have a very low failure to appear rate in Connecticut. It's much lower than the national average. We've adopted all sorts of policies to try to get people to come to court. We text people their court date if they want us to, and that's been actually quite effective to get people to know their court dates. Obviously, we have a database through the judicial branch website where people can look up their court dates. Now, there are people that don't come to court, and that's a factor. But again, our failure to appear rate in Connecticut is actually, I don't know the exact number. I think it's about 20%, something like that. 16% is a failure to appear, which is compared to the rest of the country actually quite low.
That's not flight. That doesn't mean actual flight, does it? That means they just failure to come to court.
I think it also varies by jurisdiction within Connecticut, because, I mean, we are a small state. We're bordered by 3 other states. So if you talk about, fleeing the jurisdiction from a place like Danbury, where people will literally just drive across the street and be in a different state, you'll see that being a much bigger problem in certain jurisdictions than it would be in, say, a New Haven.
It occurs, picking up on something that Mark Maurer said earlier, and I have found over the course of my life, I often pick up on things that Mark Maurer said earlier. He talked about having a responsible adult of one sort or another. And if the purpose is to assure appearance in court, don't we have at least as good a chance of accomplishing that if we have a responsible adult, an active bail commission, some system of pretrial services that keeps after people? Aren't we likely to be at least as effective in getting them to court that way than by placing financial conditions on them?
I mean, I think that's true, and that all the data shows that whether they're juveniles or whether they're adults, but the single thing that affects people's success or lack of success coming through the criminal justice system is some sort of community-based support, whether it's a family member, a church group, or just a neighborhood. As we sort of work these details out, that's one of the things that ends up sort of heightening my level of concern, because how do you judge that? And that is unfortunately still a very subjective assessment. I think socioeconomic status comes into it. How do we decide who's a responsible adult? How do we decide who's appropriate? And I think those are things that are really difficult to legislate. So as we're moving through this discussion about bail reform, I think it's really important that we make sure we look at that every time we talk about something that's going to impact or help somebody be released from jail or be more useful than money bail, that we make sure that we're going to be able to apply that in an equal way to everybody that comes into court.
Although, as you point out, we do have state agencies that can act as surrogate responsible adults by providing at least some of those services.
So in colonial America, before there were bail bondsmen, the actual original sureties were people who stepped forward and said, I will guarantee that this person comes to court. They would be someone who would have some stature in the community. And so the first original idea of sureties in criminal cases in colonial America was, I go into court, I'm going to guarantee that this person's going to come, I'm going to make sure of it. And they gave a guarantee to the court, and that was deemed as sufficient to guarantee the person's appearance in court. It was only later, probably after the Civil War, that we got into this money bail situation, and which is now dominates our pretrial release. But the idea of a responsible adult was the original idea of sureties to begin with.
And I think when you talk about the government taking on that role, I think the important discussion is also about resources here.
For sure.
And that, particularly when we talk about some of the jurisdictions that have gone down this path, the level of resources that are provided both on the prosecutorial side, on the court side, are very high. When you look at the D.C. court system is funded at a level of $400 million for a system that serves 600,000 individuals. That's a lot. That's a level of funding that people in this room would certainly like to have, and that's what you get when you're the
Sure.
The federal government runs a local entity. So those are the kind of things. That's obviously a very serious concern for members of the division, because we're asked to make these decisions. I mean, at the beginning of this process, there's going to have to be a prosecutor who says we're going to seek detention or we're not going to seek detention, and that decision has to be made with enough facts, enough time, and enough resources to be able to make a decision similar to our charging decision. And those are, very serious matters that, and I know the public defender would be thinking along the same lines, that they need to be fully prepared when someone's all or nothing liberties is at stake very early in the process. So, I think that, while having this debate, we also have to have concurrently the discussion about resources and how this would be funded, because if not, then it's all just pie in the sky.
Fair enough. Let's see if we've provoked some questions. Okay, who's got the mic?
I just want to push back a little bit on Ms. Rapillo's argument that essentially if you have cash bail, then there's always the chance that someone can get out, where if they're held preventatively, they can't. I come at it from a different perspective. There will always be errors. No matter what system we use, there will be some people we detain who we shouldn't, and there will be some people we release who we should not have. We'll never eliminate the errors. The question is, what is the source of the error? In a system of preventative detention, the source of the error is that presumably a public servant looked at all the information, did the best job they could to make a determination of the risk this person faced. With bail, the source of the error is that a bail was set based on the severity of the crime, and some person could get the money together and some person couldn't. And so the source of the error with cash bail is just intrinsically unfair, where there's less, I at least think, with preventative detention, less concern about sort of judgmental errors that will, in part, contribute to the errors that happen.
I don't disagree with this idea that the cash money bail system is unfair. What concerns me, what we tried to do in Connecticut is to remediate some of the unfairness by providing a robust array of services for people so that our clients still have an opportunity to get out because they're able to participate sometimes in a state-funded service. What worries me about preventative detention for a wide range of crimes, and again, as you shrink the number of crimes that people are eligible to be preventatively detained for, then the concern lessens. Because what I'm worried about are those people in the middle. So many people with low-level offenses who are getting out will continue to get out, but there's a group of people in the middle who right now are out, not reoffending, not failing to appear, who are likely to end up incarcerated as a result of a system of preventative detention, depending on how we define what's eligible to be detained. So that's the worry. Even under a preventative detention system, money is going to make a difference, because if you can afford to go out and purchase the services that will ameliorate your risk, the system is still going to be better off for people with money. If we figure out a way to make the system fairer and apply resources so that the services that will keep somebody out or prevent somebody from having to go in are more equally available to folks, then I think that's a good way to start to look at the system. Again, we're talking about preventative detention for a wide array of charges. My level of concern increases.
Very recently, we had an individual in Connecticut post a $6 million bond, right? I might be familiar with the case. And so I think we have to think about what was done there. There was a legal proceeding where parties argued for a certain outcome, and in the end, that bond was imposed, and the individual was able to post it, right? So it seems like as a system, all we've done was to transfer money from one wealthy and potentially dangerous individual and transfer it to a for-profit bail bond industry that really doesn't exist anywhere except the United States and Philippines, right? And we have to be honest about how many people of color have been able to post that type of bond, $6 million, $2 million, or $1 million, right? And that's part of our bail system. On another note, I have a question about pretrial conditions, services or treatment by a different name. What are the opportunities that you see when it comes to services and treatment if we're to move away from money bail? And also, what are the dangers there in over-conditioning? Because when we remove money bail, we don't want everyone walking around on GPS devices, right?
So the issue with rich people in murder cases or very serious cases being able to post bond, those are of concern, and those are also kind of at the fringes of the system. When I think about, and when the people in our division and this has been a discussion that we've had across the staff of the Division of Public Defender Services. What is that going to look like for most of the people who walk into court? I mean, it's not, most folks who are being charged with murder are going to have a high bond set, and many of them, it's the extreme person that's going to be able to post a bond like that. And maybe there's things that can be done to address that. If that is a real concern for public safety or for failure to appear, then there can be discussion on what do you do with folks who may really present that sort of a risk to society. But my concern is the thousands of people that end up in the middle. And if you move to preventative detention, who ends up incarcerated that way? Politics come into play. There's different kinds of cases that offend the public. Domestic violence cases are a big one. Those are dangerous, scary, difficult cases. But the reality, too, is that there's lots of them. And there's a number of people who are accused with domestic violence offenses who are out and who are not reoffending and who have an ability to work and to raise money to continue to support the family that exists as part of this. And how much of a lot of those folks would end up incarcerated. I know people will differ with opinion and people will think that's okay. That's just an example of them. There's a lot of other cases. You would have people who are out in the street repeatedly selling drugs. Should those people be incarcerated at a higher rate than what they are now? So the concern is for the stuff in the middle, for misdemeanor cases, people getting into fights, people with drunk driving charges. There's a whole range of things for which you'd have to figure out what really makes somebody dangerous to the point that you want to preventatively detain them. But I think the question about services, and the worry that you would over-service people, you have to sort of focus on different parts of the system. Connecticut has also been working to try to divert more things out of the criminal justice system. The prosecutors have a really interesting program where they're pre-screening cases and pushing them out of court really before they even come in and see the judges. In most jurisdictions, those folks still get to talk to a public defender or a defense attorney, but the cases never come in. I think if we're going to talk about bail reform and moving to a system where you can eliminate money bail and some charges and preventatively detain people, you also have to put some resources in figuring out what should be coming into the criminal justice system. And so putting resources towards that would be important. Obviously, anything that impacts mental health or substance abuse impacts everything. That's what drives drug cases, most domestic violence cases. If we could put more resources there, we would be able to keep more people safely in the community.
And if I can just comment on that, I think that that's something, as Zahner's already pointed out, that we are kind of a product of our own success, is that we have been pouring a lot more resources into those areas. And, that's one of the reasons why I think the numbers that we've talked about earlier are coming down. Some of the, all the stuff that we're talking about has happened in the last 10 years. Also in the last 10 years, our incarcerated population has dropped by over a third. So, and I think that that's also a testament to kind of a culture change within our system of justice. I know I've seen it in the prosecutors' offices throughout the state and the public defenders' offices and certainly the judges, that there is, particularly in the area of bail, more of a culture of release. That is something that is important. The legislature has supported that in that, like if you're charged with a misdemeanor and you're held on bond, you automatically have to come back in and have bond readdressed in, I think it's 14 days. It's like every 14 days you have to come back in so that they can relook at that particular issue. So I think we have been doing a lot of work in this area. We do understand how it appears when someone who's on a $6 million bond walks out. I mean, that's obviously of extreme concern for members of the prosecutor's office. But it should be a concern for everyone. And, I think that, regardless of the totality of the reform that we're talking about here, that those types of measures have to continue and that we have to continue to invest in the things that we're doing now that have proven over the last decade to be correct.
But if you look at bail, money is a proxy for risk. I mean, the judge decides to set a $20,000 bond, a $50,000 bond. That's a proxy for an assessment of risk. Risk to come to court, risk of dangerousness. So if you have two persons that are in front of the judge sets a $20,000 bond on each of them. One person posts bond, one person doesn't. They're the same risk. That risk has been monetized to $20,000. One person's out walking around, And as a society, we're okay with that person with that $20,000 worth of risk walking around the streets. And the person who's in jail on that $20,000 doesn't have the money to post a bond. It's the same risk. It's just the money. If they had the money, they'd be out, and we'd be okay with that. And because they don't have the money, they're in. It's the same risk. That's the problem with this system. If money's a proxy for risk, why not make risk risk? If you really are risky, you're in. But if you're not, you're out. And if we have to cobble together some conditions to sort of mitigate concerns, we do that very well in Connecticut. And the question about, getting money together to post bond, I think theoretically that's true, but we know that people who do not post bond within the first 48 hours of their arrest don't post it. They just don't. I mean, that's why the judge sets a bond. The judge doesn't know if the person's going to make bond or not. That's why we sort of truncated down the amount of time where people would come back to court to get a review on their bond, because the judge would see, look, I put a $10,000 bond on this person. I thought they'd post it. Now they didn't. Maybe we should revisit the whole situation then. So there's some people that post bond as their case works its way through the court, but actually not a lot. Not a lot.
Your example of the two similarly situated defendants raises an interesting point, one who makes bail, one who doesn't. And that's this. I haven't seen statistics on this in quite a while, but I doubt that they've changed. And that's that those who are not incarcerated pending disposition are far less likely to receive a sentence of incarceration on the back end of their case. And even when they do, it tends to be shorter than those received by people who have been incarcerated. There are a variety of reasons for that, some good, some bad. Among the bad, delay tends to favor the defense. The longer a case is pending, the more likely it is that a witness will disappear, forget, die, any of a number of things, or be tampered with, a number of things that will affect the vitality of the case itself. We also know that there is a stronger motivation among people who are held pending disposition to plead guilty than there is among those who are not. People are in jail for a couple months. I want to get out of here. Let me take a plea and go home. Somebody who's out may still want to plead guilty at some point, but won't have that same rush, that same immediacy of a need to get the case over with. But there are some other and better reasons for why that disparity exists or could exist, and that's this. The person who is in jail can do relatively little to enhance his or her status when it comes time for sentencing. The person who is out can maintain employment, obtain employment, start working on restitution with the help of a good defense attorney who can, responsible adult, push in the right direction. That person can do a lot to enhance his or her status so that during that period between arrest and judgment day, that person will be a much better candidate for a non-incarcerative sentence than would the same defendant who is stuck in jail. That's powerful. And it's something really, I think, to give a lot of thought to when we try to recognize the importance of making sure that people who don't need to be held are given that opportunity to use the predisposition period constructively, again, hoping that they're being properly advised and helped, and that some services are available along the way to make it happen, rehab, and so on. It seems to me that's a pretty important factor.
I mean, I think we should all be working towards a way to limit the use of money bail. And if there's a way to eliminate it, where we can implement it in a way that gets fairly applied to everybody, then we should be moving to do that. Because I agree with everybody that people should not be in jail just because they're too poor to post it. And Judge Devlin's example about the two people with the $20,000 bonds hits home. Yep. Because it's two similarly situated people. We should absolutely all be working towards that. The concerns that I'm expressing are the things that we need to watch out. It's easy to say, it's easy to get up and wave the banner, let's eliminate money bail because it's unfair, because it is, and that's right. But how we do it is critically important. So I just think our concerns are that it's important to be very careful about it, to make sure that we know what are all the details going to be before we make this. In Connecticut, this requires a constitutional amendment. So if you make the decision to eliminate money bail, you can't really take it back if you're not able to work out the details in a way that works for everybody. So that's been one of the concerns. I think as we move forward with this, and we absolutely should move forward with this, we just have to be mindful that the details are going to matter a lot to the folks that we're trying to help here.
The choice between in or out is a much starker choice than PTA, $500 bond, $10,000 bond, $20,000 bond, and on up. If that's the decision that a judge is being called upon to make, in or out, no other choice, it gets pretty scary.
Again, I think that's something that, we have to remember, that this is going to be something that translates into, 80,000 cases, that the unintended consequences that Chris is pointing out, and I think that concern everyone here, and that is the devil in the details, is how is this going to translate into a system where in or out is going to be made 80,000 times. That is something that we have to be sure is correct, not only for the defendants, but for those that are the victims of any of these crimes, and for, the members of the public to be assured that the system that's being put in place will protect them.
And no judge, prosecutor, or defense attorney wants to be in favor of the out decision and then reading the next morning that the person sodomized a nun or something, right?
I think
It's the horror
that's a
story.
very real, that's obviously a very real concern, is that, everyone in the system is risk averse. That's just the nature of the beast. And I think that all of this just needs to be thought out in a way that we can create a system that assures public safety as much as we can, and assures fairness as much as possible.
Listening to this conversation, I think it's really nice to hear that, we all have concerns, but we all still want to work towards progress. I just want to make the point that sometimes inaction can be action at the same time, especially when it comes to public policy. Every action that we're taking has unintended consequences, whether we like it or not. And the best that we can do as a group here is have these conversations. So what's really great is there's other states that are working on this at the same time that we are, and we can learn from those other states and kind of see, the foggy middle when we're making these decisions on the eligibility of different people. We can kind of see as other states make that progress for us at the same time. So I think that this conversation, although it's kind of been, obviously differing views, it's been really constructive, and that makes me feel really positively about the changes that we can make.
Okay, some more thoughts. Help us out.
Hi, I'm Margaret Levy. I'm a criminal defense lawyer in West Hartford. As a practical matter, we have a system of preventive detention in this state for indigent defendants charged with serious felonies. A judge certainly knows when he or she sets bail at $300,000 or $500,000 or $1.5 million or more for a person who has been found to be indigent and whom no one is questioning whether they're indigent, that bail is going to keep the person in jail, in prison and maybe at Northern for as long as it takes to finally get around to settle that case. What's not clear to me is whether the proposal to do away with money bail, but in effect to go to something like the federal system in which individuals are either detained or released, will result in any different and less detained situation for those individuals.
The Chatelier's principle.
I think the reality is for the most seriously charged people, it may result in more people being detained because somebody would not have a $6 million bond set. They'd be determined to be dangerous, maybe based on the charge, and wouldn't get out. So the amount of impact it has on the folks with the highest bonds currently and the most serious offenses might be somewhat limited to those few people that are able to post the high bonds. The impact would, again, more be on the folks, in my opinion, would be more on the folks in the middle.
Sir.
So I want to, I guess, strangely enough, put a point on Attorney Rapillo's comment. I think it's important. I think if we're thinking about the system, I want to eliminate money bail as well. But I think when we when we move to another system, we have to think about what that system is. And I think what we're talking about here is equity, the issues of race that are in the criminal justice system. And one of the ways that this gets done is you use tools to do it. It's not just purely an assessment by a judge. It can be that, but it's usually you use a tool which takes away, we think, some of the subjective nature of this. But what we know is that those tools are based on a racialized system. And so when you have a tool that is based on a racialized system, you've just imported race back into the tool. And so we should be moving in this direction, but we should give deep thought to what is being presented here, because what we do not want to do is say, well, a system functions in a way that the indigent and people of certain races cannot find the relief that they want, so we're going to have this neutral tool, which is in its very creation not neutral. And I think that's just a point we need to ponder a little more deeply than it seems to be happening in this conversation.
Well, our bail commissioners have a tool, and it's maybe imperfect, and maybe could be improved. I have no doubt about that. But you know, if it sets the midpoint at 0, and it calibrates all these factors, and if your score comes up as a 0 or positive number, they're going to recommend a non-financial release to the judge at your arraignment. If the number is in the negative territory, the bail commissioner may or may not recommend a pretrial detention or a bond, money bond. Right around -7 is where we see sort of the real that's the real mark, where we see people getting bonds that in many instances detain them. But you're absolutely right. It can't be just seat of the pants kind of stuff. I mean, you have to have a tool that's been validated, that is race neutral, that makes a valid, honest assessment of the person's risk, and use that as at least a first step in deciding, well, who should or should not be, submitted to the judge for possible pretrial detention.
I think there's a question back there. Yep.
Yeah, I'm Corey Mainville, the public defender in Torrington. Judge Devlin, what you're describing is a very objective system, and I love your example of the two people who are similarly situated with the $20,000 bond. However, the reality is, in this state, depending on the jurisdiction you're in, the judge, the bail commissioner, various players in the system, those two individuals might have very different bonds. It's not objective. And so my concern is, how do we make it objective when we know it's so subjective, even not just bonds, but what people are getting for sentences? So I love the concept of objectivity, but the problem is we don't have that. It's very subjective. And I wonder if you have taken a look at that so you can look at the numbers. What is someone getting on a bond in this jurisdiction with this judge as opposed to another? And judges don't always listen to the bail commissioners.
I thought you've seen one judge, you've seen them all, no?
I mean, that's a cost of judicial independence. I mean, do we want judicial independence? I think as a general proposition, we do. And one of the costs of judicial independence is different judges will see cases differently, and some will, and they run a spectrum in terms of their policies on all sorts of things. But I think the alternative is worse. The alternative is worse, but I will say this: if you went to a no-money bail situation, the judge would have to confront the evidence that was presented, the real evidence that was presented to support or refute the claim of the prosecutor to detain this person, and there'd be a record made of exactly what the basis of that decision would be, and you'd be in a much better situation to compare results, judge to judge or defendant to defendant, to see if there was some disparity there. That's all I can say about that.
I agree, and I also think that if we have a subjective system, and until we can find a way to objectively have this system, which I think is a long way off just based on how things are run, if we have a subjective system based on the different judging and all sorts of different factors, one way to eliminate part of that subjectivity is to have strictly based on risk or whatever tool is determined to be used, rather than money, because that eliminates at least this kind of filler in for a risk assessment, which people are using as money, which doesn't apply fairly to people based on risk. It's applied based on ability to pay. So in a minimum, it would eliminate that inequity. Obviously, there can be further discoveries related to objectivity, but in the minimum, that would be something very effective.
We're about at our conclusion time. Let me just make one observation. It's clear, first of all, that there are no easy answers to this problem. That should not be a surprise. One thing that's emerging, though, is that bail reform and even the reduction, perhaps elimination of money bail, can be accomplished, but at a cost. A cost in terms of providing additional services, a cost in terms of what it would take to conduct the kinds of hearings that it would take to get the information fully fleshed out before the in-out decision is made, and a cost that we haven't really talked about yet, which is that if my theory is correct, and that people who are not being held in lieu of bond are not going to be in such a hurry to plead guilty, it means that caseloads are going to increase. It's going to take longer to resolve cases, and both judges and prosecutors and defense attorneys are going to be busy longer with the same cases. So something to think about is whether there is sort of a cost-neutral way of dealing with this that factors in the fact that we're going to have to spend more money on the front end to conduct hearings, to provide services, and so on. But seeing how that might measure up in the long run against the savings, not only in pretrial incarceration, but in improving the quality of post-dispositional results so that there's fewer incarcerated sentences on the back end. Maybe that's the way to make the numbers work out. A thought. Yeah, please.
So as of January 1st, our practice book rule was changed so that if someone has a bond set of $20,000 or less, they can satisfy that bond by posting a 10% of that bond with the clerk's office. And at the end of the case, if they show up in court, they get that money back. Okay, so this is a change in our law. You can do it right at the police department. A lot of people here are on the front lines dealing with people who are arrested. So I just want to mention that as a, I think, important change in our law, which may well affect at least some people who will be willing to maybe have people help them out to post a bond with the idea that they get the money back at the end of the case. Thank you.
Thank you. Thank you for your attention.